Tech in the hot seat. Google CEO Sundar Pichai testifying today in the government's antitrust lawsuit against the search engine. The Justice Department alleges Google broke antitrust laws to keep its search engine dominant in the space, while Google says its success comes from having a good product. Pichai testifying today, Google faced a, quote, very competitive dynamic when specifically trying to get a deal with Apple. The implications of the trial are massive as the government tries to rein in big tech. For more on this, we turn to Harry First, professor of law at NYU. So, Harry, thank you so much for joining us. Let me start, Harry, by Sundar Pichai taking the stand today. What's his mission there, Harry? What is he trying to accomplish with that testimony?
Well, I think, first of all, the overall story that Google's trying to tell is that this is a fabulous company. It succeeds on its merits. Consumers love it. It gives them a great product. And hey, we've done nothing wrong. We've won fair and square. So that's the first thing. And then, of course, there are all the particular issues of the trial, which is, who are their competitors? Why does he think they're in a very competitive environment? Ultimately, why did they pay so much money for the default status? What does that mean? So those are all things to address as well.
Harry, it's Julie here. Let's take that last bit for a moment and linger there,
right.
Because indeed, that's a big number that we learned about last week. $26 billion that the company paid in 2021 to be the default on mobile phones. What does that do to Google's argument, that big number?
Big to you, small to them. I don't know.
Right.
Right. Yeah. I don't have that many zeros in my pocket, but they apparently do. So this is a number that's hard to explain. What exactly are they buying? And I don't think they necessarily want to explain that. They pay a lot for customer acquisition, as it's called. And this is part of it. And it's a competitive race. They say that, they compete with other companies for this position of default. And, others can try to bid for it as well. So it's not so much that they can explain why it's so valuable. It's why it doesn't exclude others. And why that shouldn't be, so predominant a fact.
And Harry, what do you, bottom line, though, just make of Google's defense? I mean, Google will say we are big and powerful, and the reason we're so big and popular is because we make a product that a lot of people like. And if you don't like it as a consumer, by all means, switch to a different search engine. You find that convincing?
Just a click away, right? Yes. Well, I'm not sure about the argument, but I think I'll Google it. So that was a joke, by the way. I don't think they want to make an argument that we're big. I think they want to make an argument that we're right scaled, and that we, because of our efforts and because of our algorithms, it's not so much our size, but the money we invest in our algorithms and giving search results fast and full and accurate. This is what consumers want. And after all, you might say, and courts do say, antitrust is a consumer welfare prescription. It's about benefiting consumers. And consumers have voted with their clicks. So as they would like to say, although people deride this argument to some extent, competition is just a click away. They can always, go to Bing, go to DuckDuckGo. And why don't they do it? Because Google's better.
I DuckDuckGo all the time. No, I didn't.
Me too. I agree. I agree.
But just to take a step back for a second, I mean, you've been in the antitrust game for a long time. And so I'm curious how you situate this case in the broader trend that we have seen of this Department of Justice being relatively assertive when it comes to these kinds of cases, but they've really had a mixed record. How important is that? How important is this case for them to win?
So it's pretty important. So if to put it in the context that you did, the Justice Department took a 20-year nap in going after dominant firms and in going after tech firms. So it was in the last century, the last millennium, when they filed the case against Microsoft in May of 1998. So it took 20 years before another case was filed. And that was a time when these big tech platforms that we know have come to dominate U.S. economy, that's the time they were growing. And they basically grew without drawing any antitrust fire. So that time has ended, at least in terms of bringing cases, because there are now cases pending against Google, against in some way against Microsoft, but against Facebook, against Amazon, and the cases are now being litigated. But we have to see yet what the results will be, so that we don't know. But so that's why it's important, of course, as you indicated, really, for the government to win these cases, not just to bring it. And bringing them and losing the cases, well, it might tell us that we need some changes in the law, but I think from a government enforcement point of view, they'd rather find out that the law was suitable and was there and could be used. So, that's yet to be seen.
Yeah, especially given maybe some of the difficulties in changing laws in this current moment. Harry, first, once we get that verdict, we'll have to have you back to react to it. Thank you so much. Appreciate your time
Thank
today.
you. Thank you. Glad to talk to you.